the use of Markush patent claims and why they can be a powerful tool in the arsenal of a patent attorney. This video is going to explain that. So my name is Derek Fahey. I'm a registered patent attorney and intellectual property attorney of the Plus IP firm. And I'm going to tell you a particular case that recently got heard at the Patent and Trial Appeal Board. The name of the case is Ex parte Min Fin Chin and Su Yin Shu Chao. And essentially, this case is a great example of two very important lessons. The first lesson is the power of the Markush patent claim. And the second lesson is sometimes examiners get it wrong, and you have to challenge and appeal their decisions because they're wrong. And in this particular case, there was a patent application filed by a company, and the particular claim that was at issue, the particular element that was issued was regarding a particular alloy and the combination of two or more elements in this particular alloy. And a Markush claim is a patent claim that's limited to the group that's selected from a set of elements. In this particular claim, the Markush claim, they specifically said an alloy comprising of two or more of the following elements, and it gave a list of 5 different elements. And what's important about the Markush claim is when you list those particular elements, it's really only that particular list. And it's a very narrow claim, and sometimes that's actually all what you're looking for. In this particular claim, it was regarding an ultraviolet mask that's meant to deal with extreme ultraviolet light. And the patent claim was claimed in such a way that it would only allow for two or a combination of two or more elements. And the examining attorney, they cited a particular reference called Jindal. The application number is 2018-013-1964. And in that particular, well, at least the examiner, in this particular case, the examiner argued that that particular reference taught this specific combination that was claimed in the Markush patent claim. Side note, the term Markush is from actually an inventor that was long ago, so to speak, in the patent world, and the inventor actually used a particular combination of elements. We use Markush claims with the language consisting of, so that we can try to narrow the scope of the claim. But in this particular case, for the examiner, when they cited Jindal, the application number 2018-003-1964, the examining attorney, according to the Patent Trial Appeal Board, misquoted the language of the claim. That particular reference, it only said that you could use one of the following elements. And the examiner rejected. They had a final rejection. That's a second rejection. Then the applicant appeals. The Patent Trial Appeal Board actually issued a very short opinion. I think it was less than 10 pages, but essentially said two important points that I think is really important. The first one is, I think the exact language was the examining attorney actually misquoted the language. And why is that important? It's because sometimes, when you read at first an examiner's rejection without looking at the prior art, it can seem very difficult to overcome. But in this particular case, when you look at the actual reference that was cited, the examiner misquote the actual language. And I thought it was very interesting because I'm going to read here from my notes here. It says the examiner misquotes Jindal and states that it includes an absorber material selected from the group consisting of, and it gave the elements. And the Patent Trial Appeal Board actually says nowhere does Jindal state that an absorber layer may comprise more than one material, which I thought was really interesting because when you're dealing with these kind of rejections and you're potentially using Markush claims to get something that's patented, you can actually need to be very careful when you're looking at the references that are cited. The second important point related to the opinion that I thought was really interesting was that the use of boilerplate language in the rejection by the examining attorney. He used boilerplate language that said in Jindals that said particular features, structures, materials, or characteristics may be combined in any suitable manner in one of the following embodiments. And the PTAB actually said, quote, that falls short of teaching to combine two or more materials in an alloy in any layer of the absorber. And why is that very important? We see that a lot in patent law, this rejection, citing this boilerplate language that's included. And for Markush patent claims, you can actually use the fact that this is a narrow set of this is a narrow claim or a narrow invention against the examining attorney. And that's exactly what the attorney that argued this particular appeal brief stated. And, quite frankly, the appeal decision, the decision issued by the PTAB, Patent Trial Appeal Board, was very short. But, I really do find that's a really great example of when you can appeal a decision. And again, it teaches two really important points. One is you need to look at the prior references very carefully, especially when you're dealing with Markush patent claims, because the examiner may be misquoting things. They may not intentionally do it, but sometimes they do. And the second thing is pay attention to the boilerplate language. You'll see a rejection where the examining attorney uses the boilerplate language to support a claim of obviousness. So just pay attention to that. Look to see if that boilerplate language actually teaches that there's a reason to combine the particular set of elements, or that the particular element is taught. So I thought this particular case was very, very interesting and is very helpful, and is a great reminder for examining attorneys and also for litigators to pay attention to what is being cited. Thanks for watching. I really appreciate you being here. If you made it to the end, please like and subscribe to the video. It helps my family and my team's family. Have a great day. Thanks.